Okay guys, welcome. This is Jared Goring again. This is my chapter 7 case study over the case Kelley versus the Board of Trustees. I'm going to go over the facts of the case, the arguments on both sides of the case, the court findings, and the implications for the activity and athletic administrator. First off, with the facts of the case, on May 7th of 1993, the University of Illinois announced that it intended to terminate 4 varsity athletic programs, including the men's swimming team. William Kelley and all of the members of the University of Illinois men's swim team, the plaintiffs, brought suit against the Board of Trustees at the University of Illinois, stating that it alleged that the defendants violated the Title IX Act of 1972 and the Equal Protection Act of the 14th Amendment. So they brought this suit against the chancellor of the university, the athletic director, the associate athletic director, and the plaintiffs were complaining for damages sought, as well as to form an injunction prohibiting the defendants from terminating the men's swim program. In response, the defendants then filed a motion to dismiss, which the parties agreed to convert to a motion for a summary judgment. Plaintiffs moved for a preliminary injunction. The district court then granted judgment in favor of the defendants and found that the request for a preliminary injunction was therefore moot, and then now the plaintiffs are appealing. Pretty much Title IX, guys, of the Education Amendments of 1972 provides that no person shall, basis on your gender, be excluded for participation or be denied the benefits or subject to discrimination under any educational program or activity other than those specifically described in the Act. In 1974, Congress requested that Secretary, Department of Health and Welfare prepare and publish regulations implemented to the provisions of Title IX, including with respect to intercollegiate athletic activities. This allows schools to field single-gender teams in certain circumstances, but requires them to provide equal athletic opportunity for both male and female. The chief among these of primary concern here is whether the selection of sports and levels of competition effectively accommodate the interests and abilities of members of both male and female. Okay, some other facts about this case. The institution may violate, so for example, Illinois may be in violation of Title IX solely by failing to accommodate effectively the interests and the abilities of student athletes of both male and female. In 1979, again, the Department of Health and Education and Welfare, in an effort to encourage self-participation, issued a policy providing guidance on what constitutes compliance within this law. Number one, whether intercollegiate level participation opportunities for male and females are provided in numbers substantially proportionate based on their respective enrollments. Number two, members of one gender have been and are unrepresented among intercollegiate athletes. Number three, where members of one gender are underrepresented among intercollegiate athletes, and the institution cannot show continuing practice of program expansion. So, thus in 1993, for example, while women comprised 44% of the student body at Illinois University, they accounted for only 23.4% of the students' intercollegiate athletics. It was then that the decision was to cut men's swimming program, faced with a significant deficit in the athletic budget, over $600,000 before the receipt of an unanticipated income from a college football game. The university determined it would need to reduce the athletic costs significantly in order to be in compliance. Determined to only field teams capable of competing for championship in the Big Ten Conference, the university concluded that it would have to discontinue certain intercollegiate men teams in order to eliminate this deficit. While the university's decision to reduce its athletic offerings was motivated by budget considerations and other considerations, while the university's decision to reduce its athletic offerings was motivated by the budget considerations, other considerations, including the need to comply with Title IX, influenced the selection of this particular program to be terminated. The athletic director, defendant Ronald Gunther, in making his recommendation, Gunther evaluated all 19 sports currently offered at Illinois, and he offered this against several criteria. Men's swimming was selected for termination because, among other things, the program was historically weak. Swimming is not a widely offered athletic activity in high schools, and it does not have a large spectator following. The university did not eliminate the women's swim program, however, because the school's legal counsel advised that such action would put the university at risk of violating Title IX. The percentage of women involved in intercollegiate athletics is lower than the percentage of women enrolled at the school currently. If the university had terminated the women's swim program, it would have been vulnerable to finding that it was in violation of Title IX. Okay, some of the arguments of both sides of this case are as follows. The plaintiffs contend, however, that discrimination on the basis of sex into a statute that mandates discrimination against males. If a university is required by Title IX to eliminate men from varsity athletic competition, then the same Title IX should require the university to eliminate women from the academic departments where they are overrepresented and men from the departments where they have been underrepresented. Such a result would be ridiculous, as the court has found. However, Congress itself recognized that addressing discrimination in athletics presented a unique set of problems not raised in areas such as employment and academics. Congress therefore specifically directed the agency in charge of administering Title IX to the issue with respect to intercollegiate athletic activities, regulations containing reasonable provisions considering the nature of particular sports. Plaintiffs, while they concede the validity of this, argue that the substantial proportional test contained in the agency's policy of that regulation establishes a gender-based quota system, a scheme that they allege is contrary to the mandates of Title IX. Even if substantial proportion has not been achieved, a school must establish that it is in compliance by demonstrating that it is either continued practice of increasing the athletic opportunities of the unmisrepresented gender, or that its existing programs effectively accommodate the interest of that gender. Moreover, Title IX does not require that all teams be co-ed, a point the plaintiffs concede. Schools must provide some means of establishing that despite offering single-gender teams. They have provided equal opportunities for both male and female. Undoubtedly, the agency could have required schools to sponsor a women's program for every men's program parallel to that. The plaintiffs would be doubtless, however, preferred that the appropriate approach, since had been adopted, the men's swim program would likely had not been saved. Requiring parallel teams in it is a rigid approach that denies the schools the flexibility to respond to different athletic interests of both men and women. Okay, the court findings of this case, Kelley versus the Board of Trustees, are as follows. The court must defer to an agency's interpretation of its regulations if the interpretation is reasonable, and the standard, the policy here, does meet that. If they are in compliance with Title IX, it is to be measured through a sort of analysis only practical that the schools be given some clear way to establish that they have satisfied the requirements of this statute. Since the policy interpretation maps out a reasonable approach to measuring compliance with Title IX, this court does not have the authority to condemn it. Plaintiffs claim that the University of Illinois violated Title IX when it terminated the men's swim program. Therefore, is rejected, and the university's actions were consistent with the statute and the applicable regulation and policy interpretation. Despite the plaintiff's assertions, to the contrary, neither the regulation nor the policy interpretation they found to become a foul dictates that of Title IX. Plaintiff's final argument was denied. The equal protection of laws guaranteed by the 14th Amendment. However, the court does not agree. First, the record makes it clear that the university considered gender solely to ensure that its actions did not violate the federal law. While the effect of Title IX and the relevant regulation and policy interpretation is that if institutions will sometimes consider gender when decreasing their athletic offerings, this limited considerations of both male and female, however, does not violate the Constitution. Okay, the implications for the activity and athletic administrator are as follows. Title IX stated its objective is not to ensure that the athletic opportunities are available to women necessarily increase, but that they are equal for both male and female. Rather, its purpose is to prohibit educational institutions from discriminating on the basis of your gender. Allowing a school to consider gender when determining which athletic programs to terminate ensures that in instances where overall athletic opportunities decrease, the actual opportunities available to the unmisrepresented gender do not. And since the remedial scheme here at the issue protects the interests of the disproportionately burdened male or female gender, it passes constitutional manner. Since the district court correctly determined that the University of Illinois' decision to terminate men's swim program did not violate Title IX or the Equal Protection Clause, its final decision is affirmed. Thank you.